Good morning. My name is Cassie McSherry. I am one of the co-owners. My husband and I own Assurity Title here in the West Chase area, and we serve the whole state of Florida.
I've had two buyers this week ask me about why the owner's title insurance premium is listed as optional to buy on the closing disclosure, and why or why not, they should do that to make sure what I'm telling them is correct. So
Oh,
either or you could start with. Just hit both of them, please.
well, let's start with that actually, because that's a big question. And so it's optional. Well, as you know, the closing disclosure is a nationwide document, but each state kind of handles title insurance closings, for example, differently, right? Some states you have to be an attorney to close, some have title agents. But when you talk about the buyer's title insurance, there are some states or areas, even in the state of Florida, to mainly Miami-Dade, Manatee, Jacksonville, those areas where the buyers pick and pay title insurance, all of it.
Yes.
Okay. So in those areas, a buyer can opt out of an owner's title insurance policy. Now I'll get to why I would never recommend that to anyone, including a brand new build, because we just had a situation where and this was in the Eagles, that the home built by the builder had an encroachment in an easement. It was a mess. And, there was like a porch in there. Neither here nor there on that. An owner's title insurance policy protects you against any situation, and I could give you examples upon examples of unreported liens, people making claims, defective deeds. That's a big one too. Someone, and specifically back, when people would just, sign deeds over to family members, a lot of times those deeds were not executed correctly. So, you could have a family member come back and say, well, I didn't agree to sell my grandmother's house and I have an interest in that property. An owner's title insurance policy would protect you against that scenario. In the contract, okay, so I just had a cash transaction yesterday closed, and after closing, the seller called me and said, why am I buying an owner's title insurance policy? There's no lender involved. I don't think I should have to pay for that. The buyer doesn't, it's a cash transaction. One thing has nothing to do with the other. Per the contract that the buyers and sellers sign, it designates who's going to pay for the owner's title policy and the lender's title policy. Typically in this area, in the Tampa Bay area, it is the sellers that pick and pay the title insurance. So if I'm representing a buyer as an agent, whoever picks and pays title insurance, so if a buyer says, no, I want to use my title company, then the buyer is opting to pick and pay title insurance in that scenario, unless the seller agrees that they can pick whoever they want. So it's like a negotiation part there, but an owner's title policy protects the homeowner. A lender's title policy protects the lender. So if a buyer opts out in an area where the buyers pick and pay title insurance, it's in those scenarios that it's optional, okay? Or in other states.
Yep. So that was the two situations. So like in Georgia, it's common for the buyer to select the attorney's office. So one was in Georgia, but one was here. For the buyer's agent, you pick the title company, says the seller didn't have to pay it, and that buyer was asking if they had to collect the owner's title policy. And I kind of said what you just said, somewhat.
It's a risk to not take an owner's title policy. It's a one-time premium. Okay, so it's a one and done, and it protects you for the life that you own, the whole time that you own the property. So it's comparatively a very minimal expense, right, for lifetime protection. Here is a perfect example of how an owner's title insurance policy protects you. We had a property in Safety Harbor that had been vacated. The owner had gone into assisted living. It was under the son's care. And that's another thing to know. Specifically in Pinellas County, all those municipalities kind of act like HOAs, right? They have the authority to put code violations, liens on properties in those municipalities. We see them often in Safety Harbor, Clearwater, Tarpon Springs. And this specific property in Safety Harbor had a couple of liens on the property. The first one, so we requested from the lien search, we find that there's some water lien. It's like $900 and something, not a big deal. We say to the son who's acting as POA for his mother, and he's like, oh, I thought it was more than that. But great, that's great. The day before closing, our closing gets postponed, mind you. Okay, so it gets delayed by a day. The day before, so if we had closed the day before, we would have closed with an outstanding $76,000 in mowing lien.
How does it get to that?
Because it was 5 years at $150 a day times, so the next day I'm terrified, right? I'm like, oh my gosh, I have to tell this seller that he knew about it. He knew. It wasn't a surprise to him, which was shocking to me because he would have closed the day before. And mind you, we would have had him sign all these affidavits stating that there's no other liens or whatever. But the truth of the matter is, if we had closed the day before without satisfying that lien and sent money out to that seller, then we would have worked to try to get that money back. But that buyer would have been protected from that $76,000 of lien that was recorded on that property.
Now, would you guys have to eat that, or the title insurance company have to eat that if you would have closed, or do you have some ramifications to go back to the seller?
Yeah, so I would try to recoup it from the seller, right? Eventually, but ultimately, underwriter, Old Republic Title, would pay out that lien. Your owner's title policy would protect you against it. That lien would be cut. ORT is going to come back to me and say, Assurity Title, you owe me some money. Ultimately, come from Assurity Title in the end, and then I'm going to have to hire an attorney, try to, fight to get the money back from the seller.
Yeah, I had a buyer that bought a house cash, a foreclosure. I think it was at the courthouse steps, and he didn't do a title search, and he didn't have a owner's title policy, and there ended up being a lien from a second mortgage that wasn't a part of that transaction, and he got completely hosed.
Well, so I did a refinance transaction yesterday, right? It's a property. It's actually up there, like in Wyndham Lake. So part of that community is in Hillsborough and part of it is in Pasco. And so when the lender, the loan was satisfied, it was satisfied, but that recorded the satisfaction was recorded in the wrong county. So it wasn't showing satisfied in Pasco County as it should have been. It was still reporting a mortgage on that property. So part of my job is to make sure that mortgages that are reporting on title are satisfied. That's part of what we do after closing. So for your buyers or for your sellers, part of my job when we close, that's not when and issue our title policy, that's not when our job is ended. Our job ends once we make sure that mortgage reporting on title is paid and the satisfaction county that mortgage is reporting.
Thank you.
So that's our responsibility. So if a buyer has or even a buyer, so if a buyer comes and says, oh, this mortgage is still reporting, Assurity Title is responsible to take care of that if we close the transaction. Title agents are responsible.
Okay, thank you for clarifying.
Yeah. And it's important to note, like owner's title policies, I mean, they protect So let's say I owned a property for 15 years and I'm still in it, but something from before comes back and somebody says, you know, there's a encroachment or something. We've been dealing with a lot of encroachments lately too, like variances and so let's go back to that example that we were talking about for that Eagles property, right? It was the builder that encroached into the easement when they built the house. It is set so much further back than the other homes on that cul-de-sac. They encroached there, you know. I can't stress to you too how important it is for agents to review title commitments. I think it's so important for you to understand when and agents should be getting title commitments. It's interesting because sometimes I hear from agents, oh, I never see a title commitment. You absolutely should. And per the contract, title commitment information, the requirements are to be shared and the exceptions are to be shared with the buyer. So it's important for agents to understand what is reflected. And you should ask your title agent, ask them what is, you know, because there will be sometimes code enforcement liens or things like that that have to be addressed. You don't want to close, you know, we won't close without them. But another thing that I thought we would talk about next time too is permit and permitting and how that impacts title. Because I think there's a lot of confusion about that. I want to get some specific examples for you, but that's what I'd like to focus on in June. Just how permitting impacts title, because it's not always a title related issue for us, but it should be important to, you know, your buyers and your sellers to have things resolved. And a lot of times,
that'd be awesome to cover that next time.
yeah, because so I'll focus on that next time.
Okay.
But
so going back to what you were giving the agent the advice, so to look at the title commitment. Now, if I had to guess, most realtors, a loan originator, including myself, I don't really ever go in and read the title commitment. Now, our underwriter does, our processor will, but like I personally don't go in and look at it unless they bring up a problem. So what would be important for the realtor? And I'm just guessing here. Are there any agents on this call that do review a title commitment? And if so, or if not, I'm sure. What is the most important things for them to look at or look for?
Well, the first page of the title commitment is going to give you just the information, right? You want to make sure the sales price, you know, the owner's title policy is the amount that the home is being purchased for. The lender's policy that's reflected on page 1, 2 shows you the loan, the value of the loan. Not that, you know, that is so important to the agent, but, you know, that's just important information. Schedule B1, that's all the requirements. So those are the things that have to happen in my office before I can close the transaction in order for me to issue a title insurance policy to the buyer. Typically, they're very simple, you know, HOA, make sure that things are clear with the HOA, municipal liens or utilities, all that has been satisfied. Mortgages, any mortgages will show up there or should show up there. So sometimes, and I'll have agents call me and say, wait, there's 2 mortgages on that property? Yes, you know, and sometimes the sellers are like, oh, is a HELOC, you know? Yes, a home equity line of credit is a mortgage on your property. Oh yeah, we owe money on that too. So just to have a good understanding, any judgments are going to report there too. So if a judgment attaches to a property, and judgments are a little, it depends because homestead properties are protected from certain types of judgments. Federal tax liens, never. Uncle Sam will always get his money, and that always has to be satisfied when the property is sold. Solar panel liens, UCC, all of those types of things are going to report on in the requirements of the title commitment. It's just important to know from a buyer side, well, and the seller side too, because the seller is responsible to our office to help us requirements. So if I need to order 2 mortgage payments or payoffs or whatever, the seller is the one who's going to provide the information to me to do that. Sometimes sellers through their agents. So if you're an agent that likes to be on the front end of that, because some agents want to handle all communication with their client, you have to know that if that's your process in how you close transactions, then you have to be very active in making sure. So my office, we order a title search, a lien search, and an estoppel the day a file opens.
Wow. Okay. I would say that probably isn't the norm. I would probably say most title companies don't order estoppels that quick.
It's not the norm, but it's the way we do it because we want to know out from the beginning everything that we need to know. We will not be surprised. And it is our philosophy, our mantra, that title will never hold up a closing. So this office, all my people know that we will never hold up a closing. We will be on the forefront of information and we will disclose it to all parties that need to, and we will continue. So if, let's say a seller's not being responsive, there comes a point in our communication. If I don't hear from a seller in 3 days and I've talked to the agent and had that happen, I put everyone on notice, buyer, seller, everybody. This is what we need in order to delay closing. But it's not because we're delaying it, it's because we're not getting what we need. Does that make sense? So we're very proactive about title clearing here. We want to know everything. I think we had talked about this, Sean, before. Estoppels, they're good for 30 days. But you receive 1 free update. Okay, so if we order an estoppel before, let's say 6 weeks out, we're going to make sure that we get that free update so that our estoppel is still good for closing. What was, I just saw.
There was a question in the chat. They were asking, why isn't it standard for, I guess, a title company to do that? And I'm guessing the answer for that is because it costs them money to do the estoppel, just in case the deal would cancel right away, right?
Yes, but if the deal cancels in 30 days, now that's where we get a little bit in risk too, right? So you would hope that if you have let's say a contract that's going to close in 6 weeks, if it's going to cancel, it's our philosophy that it's going to cancel within that first 30 days. If it cancels in 30 days, within the first 30 days, and I have a executed cancellation, the estoppel fee is refundable. It is not charged to the client. Okay, so if you have a property that's 2.5 years, or 2.5 months or something, and we wouldn't order an estoppel probably that early, because then we're out. We don't want our estoppel to expire. So we want to be timely, but typically we don't get contracts that are closing, 8 weeks out, or they're typically faster than that. And if they are, they're typically it's just interesting. They don't usually they're not in communities that have estoppels really. Sometimes, I don't know, but it just always works out for us. And the reason that not all agents do it is, they may have a different philosophy on how they do business. And I'm not saying that one is right or wrong. I just hear often in my industry from other agents that an estoppel order wasn't placed in time. And, HOAs are not required to do rushes. There are some, and they can charge an extra fee for a rush, but they're not obligated to do a rush. And there are some municipalities that won't rush a lien search, and there are some HOAs that will not provide a rushed estoppel. So if you're waiting on that, that's another thing that I don't think is really fair when, and I've heard this often too, that title companies will wait and then order the estoppel on a rush. Well, that's added fee to the seller. Estoppels aren't cheap to start with, much less adding $100, because you ordered it on a rush. So
the estoppel's good for 30 days, and you said you can do 1 free update during that 30 days?
Yes, at the 30-day mark, you can order you want it to be like 29 or 30 days. You don't want it to be and then it's good for another 30 days from that point.
Perfect. Thank you.
Hey, Cassie, I have a customer. He's going through a divorce, and the divorce is not finalized. But I know on a second home and an investment, the ex-wife doesn't need to sign on anything, right?
If it's only titled in his name, she does not need to sign on an investment property.
Okay, and if it's a primary residence,
She has to.
okay, but let's say if we're getting like a legal separation agreement, that has to be signed by everybody, or his lawyer can sign for it and we're good to go? Or it has to be signed by the judge?
Correct. First off, in any agreement, whatever, it has to be signed off by a judge. And so if they're going through a divorce, and then we're obligated to follow whatever that, that court order is. But if this is their homestead property, she has to sign. And we get into discussions about this all the time. And it's sad because sometimes, people in divorce, they don't get along at the end. And we do our very best to accommodate both parties, however they need it to happen. One of the things that we offer our clients and we don't charge them for is remote online notary. So oftentimes, someone has already moved away or whatever. We try to make it as convenient as possible, but both people on a homestead property must sign, even if they're not both showing on title. Marriage, the marital agreement, marriage locks you to a homestead property. You have rights to it. You must sign those rights away through your deed conveyance. And there's documents that they have to sign as well in terms of owner's affidavits, closing affidavits, that there aren't any judgments coming and all of that. Another thing that's important to note, homestead properties are protected, and we often have people sign continuous marriage affidavits. Once the marital relationship has ended, okay, that marital protection goes away. And so sometimes judgments can attach. Now, typically, depending on what they do, a homestead affidavit and record that. That's something that I have to get approval from my underwriter to do, but sometimes certain judgments won't attach to a homestead property, but it gets sticky when people get divorced. I typically like for them to remain married through closing and then divorced, or divorced with the actual divorce decree, because good attorneys have everything already laid out in there. And if someone's keeping the property, then someone's giving a quitclaim deed to one of the parties, or some attorneys are savvy and they'll put inside the divorce decree that, the husband has 60 days to refinance the property, and that judgment acts as the conveyance of title at that point. So
if they are not in a good terms, and the ex-wife is moving very slow and he wants to buy a house, and nothing is finalized because she's moving very slow in the process, if there is any way for him to speed up the process, or go talk to the judge, or his lawyer talk to the judge to get these things done?
Yeah, you're asking me a question that's not in my wheelhouse, unfortunately. Okay. Asked for the attorney. Sometimes it really is, however, the county, and then each county is kind of different. Okay. Some faster than others. Yeah, unfortunately, I can't speak to that aspect of it, but I can promise you that they will both need to sign if it's a homestead property. And he's trying to buy something new. Is that what you said?
Primary residence.
Yeah, then that would be a question, right, for Sean, other options, financing and that sort of thing, to move forward.
No, I was just asking you from your point of view as a title company. So it's just, yeah, me and Sean were talking about.
Well, I want to point out one thing too, on that file. I believe they were married in another state, and other than Florida, it might have been California. And we have basically paperwork from the attorneys and from the court that shows that their marriage was ended like whatever, 2 months ago, 3 months ago. However, just the final divorce decree hasn't been issued with the separation of everything, but it says that the marriage has been ended as of a month ago. So
Gotcha.
we were just listening at like in our file. I just said, well, if it says on their paperwork that is signed and everything that their marriage was dissolved and ended 2 months ago. It's just we don't have the final like decree with all the, agreements.
She would still have to sign though, because it's both their homestead property. So unless she has purchased something else and homesteaded it, it gets kind of shady there in the middle. But I mean, if this is still her homestead property, she absolutely has to. And you need something that says that the house was given to him and they're divorced. And
this is on a new purchase. This is on a new purchase. It's not on, not on a home they own. So I said, well, since we have documentation that says their marriage was dissolved, they're no longer married, we don't have the final decree. I said, well, in our file, we could technically list them as unmarried, right?
I think you'd have to, I don't know, I can't speak to that.
Okay. I mean, I guess it's up to the guy. He's telling us he's unmarried. We have paperwork showing he's unmarried. And if he's going with that, but we're telling him, hey, listen, the divorce isn't officially finalized. Your soon-to-be ex-wife could possibly come back, right?
Yeah, I would want to see a finalized divorce decree signed by a judge to feel confident in them not being married. Yeah, I mean, it's maybe California is different. I can't speak to that, but we see separation agreements or proposals for the divorce settlement, marriage agreement, dissolution agreements and stuff. But in the state of Florida, you're divorced when the judge signs off and says you're divorced. I mean, and you can close. I mean, if she was willing to close, you can close. And typically what happens is, here is the other thing, if the proceeds are not split 50-50, right? Then they both have to sign a hold harmless with us outlining how the proceeds will be signed or divided. A lot of times in a divorce decree or a marriage dissolution agreement, it's already outlined in there. They'll say that they're splitting the proceeds 50-50, but the wife gets an extra 10,000 or something. We see that a lot where one might get a little extra money, but we have to follow a court order. That's another issue. We've had clients saying, no, she owes me for whatever. We are, by law, we have to follow whatever is in that court order, unless there's something, unless they both agree to sign, which doesn't typically happen. The wife is saying, I
have a question. I did work too many loans for this case, and a lot of buyers, they come and put in the application unmarried, and actually they got divorced like long time ago, like let's say 10 years ago from that person or whatever, and they got divorced like let's say 10 years ago. How would you know? Like he said unmarried. How would you know? Because I was working at Wells Fargo and the customer, they put unmarried, and Wells Fargo underwriter doesn't say anything, even the customer said unmarried, but they didn't never ask for a divorce decree.
Right.
If this get dissolved like with the county, or it shows on his records, on his public record, he's unmarried anymore, or how do you guys see that?
Well, I'm in my closing documents, there are owners and closing affidavits that they signed stating everything that they've told me is the truth, the whole truth. You know, so they're attesting to the information that they provide to me as a title agent. On your lender side, I'm not really sure. I mean, we take people, but I've been at the closing table and a spouse has popped up. Oh, wait, you are married? Yes, but we're separated. Well, you're still married. So,
Oh,
she has to sign, you know, yeah.
no, I wondered that like, you know, when they do the application, they put an unmarried, and then I see he has 2 kids. He put on the application, he has 2 kids, for example, like 3 years old or 5 years old and 10 years old or whatever. And he put unmarried, but I never seen the underwriter is asking, and of course the you know, I'm sure he got divorced like long time ago, but I'm like, why the underwriter didn't ask for a divorce decree or
Oh,
separation?
not all people are married, have kids, right? Like some people have kids out of wedlock. So I'm not sure. Sean can speak on the lender side. I'm not sure on that side, but I mean, a lot of this is trusting people at their word. And then I have them attest to it in my closing documents that are notarized. So if something came back later, right? If someone tells me they're not married, and that is a good example of what would protect an owner with the owner's title insurance policy. Let's say this man comes to me, and this is the case too, that he may have owned the house before he got married. It's only titled to him. He tells me he's unmarried. We sign a deed, but he was married. The wife had to sign. She didn't sign. That is a clear and perfect example of how an owner's title insurance policy would protect the new home. It would protect them for the full price of what the purchase price of that house against any paying her out, whatever it is that would be owed to her for her not signing because he lied. Now I could go after him. I can get an attorney with my closing documents and say, you attested that you weren't married. You said that everything you said. So it's just a lot of work for me on the other side. But that's a perfect example of an owner's title policy protection. Is that scenario right there?
Okay, I was just wondering, it's just like,
So there's
No.
nothing you check online in public records to see if somebody's married or not on the title side.
Not on the title side. We take people for, you know, we look, you know, we can pretty much vet it out, right? Get on the phone. That's another thing. When a file opens, Peyton, who opens our file, she gets on the phone with the seller and asks all these questions and kind of talks them through our process. And, you know, typically we can vet out if something's not right, you know, but because sometimes too, and agents can talk to that, only one of the clients will sign the contract, and then we're doing addendums later to add the other title holder to the contract, you know, that has to sign that the house is being sold. You know, both title holders seem to speak to that. You know, the husband can't sell a homestead property without the wife's agreeing to it, and vice versa. So that fraud, or do you want that fraud one was a good one. But I know I want to honor people's time. I can talk to them.
We'll just take a couple minutes.
Yeah, so it was an
Okay.
investigation, and this woman had recorded a quitclaim deed to herself using the stamp of an attorney who had died in 2020. She just recorded this deed in her name and was trying to sell the property to an investor. And yeah, so that all came to be. It's crazy what people will do. So she was a squatter in this investment, this house, I guess. And yeah, so she was trying to sell it to one of our investors that we work with often. And sure enough, she doesn't even have rights to the property. So that's a new one for me. I haven't heard of anyone recording fraudulent quitclaim deeds themselves with stamps from, attorneys that have passed. So that was crazy. So that wasn't
Unbelievable.
just unbelievable, right? Crazy. But thank God, Amy did a great job in our office of just vetting everything out. And so that one's not moving forward. That one won't be closing at Assurity Title. So, and then the person that owns it, I think, is an investor too. So he's filed a memorandum just to try to protect it being sold, until they get it resolved and get her out of the house. So
Next time, will you touch base on so squatters and permits? Because this is the second time I heard of squatters this week. So can you put a note to touch base on that and the permits next time?
absolutely. So we'll talk squatters and permits. And all right. And I will put you guys into a drawing, everybody that was here today too. And I'll let Alyssa know that she got a bottle of champagne. We like to give a champagne or wine at the end of closing to all our agents and our clients, because this real estate business is thirsty work. So you guys be well.
Thank you so much. Have a nice weekend.